There is a scenario millions of Americans have never thought about that January 14th, 2026 made significantly more dangerous. Your ex-partner calls 911 claiming concern for you. Police arrive. You do not answer the door. Through a window, an officer sees an empty gun holster on your table and what looks like a note. Based on those two observations, they enter your home without a warrant. You are in a closet. You open the door holding something. A police officer shoots you. And the Supreme Court rules that everything before that trigger was pulled was constitutionally permissible. If you are a gun owner, if you live alone by the end of this video, you will know all the implications of the Fourth Amendment, so let's get into it. This is not a hypothetical. This is Case versus Montana, number 24-624, decided January 14th, 2026. If you have ever been through a difficult breakup, or if you believe the Fourth Amendment means what it says when it protects the sanctity of your home, you need to understand what this ruling establishes and why it changes the conditions under which police can enter your home without your permission and without a judge's approval, starting right now. Subscribe now because Case versus Montana represents the most significant narrowing of home privacy protections under the Fourth Amendment in nearly 2 decades, and the specific facts that triggered constitutional entry authority in this case, an empty gun holster and a piece of paper, exist in millions of American homes every single day. William Case's ex-girlfriend called 911 and reported he had made statements suggesting self-harm. Officers responded to his Montana home. They knocked and received no answer. Through an open window, they observed an empty gun holster and what appeared to be a handwritten suicide note. Based on these observations, officers entered without a warrant. Inside, Case was hiding in a closet. He opened the closet door holding an object an officer perceived as a firearm. The officer shot Case. The legal battle asked whether the warrantless entry violated the Fourth Amendment. The Montana Supreme Court ruled the entry permissible under the caretaker doctrine. The United States Supreme Court affirmed on January 14, 2026, grounding its decision in Brigham City v. Stewart, 2006, and the broader emergency aid exception. Let me break down what the court held, why the existing emergency aid exception now has broader force, how visible firearms in your home factor into this analysis, the specific situations that create constitutional entry authority, and what you must do to protect yourself. Number 1. What the Supreme Court held in Case versus Montana. The Brigham City versus Stewart framework. The foundation of Case is a 2006 unanimous ruling holding that police may enter a home without a warrant when they have an objectively reasonable basis to believe an occupant is seriously injured or imminently threatened with serious injury. The standard is objective, not subjective. It does not ask whether officers actually believed the person inside needed help. It asks whether a reasonable officer in the same circumstances would have believed emergency aid was needed. Officer motivation is irrelevant. If objective circumstances support a reasonable emergency belief, the entry is constitutional. What Case versus Montana added, the court applied and solidified the Brigham City framework to a combination of factors, a third-party self-harm report, visible evidence suggesting means for self-harm, and occupant non-response, that together create the objectively reasonable basis the Constitution requires. The court held that no single element needs to independently justify entry. The combination does. A report alone is insufficient. Observable indicators alone may be insufficient. Non-response alone is insufficient. But all three together cross the constitutional threshold. What the court said about motivation. Emergency aid entry does not depend on officers' motivations or ultimate purpose. If officers are present for emergency aid and objectively reasonable circumstances support entry, the fact that they might also collect evidence during that entry does not retroactively convert it into a Fourth Amendment violation. The entry is evaluated based on circumstances that justified it, not consequences of it. Why this matters beyond the single case. Case transforms the emergency aid exception from a rule requiring clearly visible ongoing emergency into a rule permitting entry based on inference. Observable evidence plus third-party report plus non-response creates constitutional entry authority. That inferential standard has wider reach than prior doctrine suggested. Number 2. How visible firearms factor into the emergency aid analysis. The empty holster as constitutional evidence. In Case, the visible empty gun holster was specifically cited as one of the observable facts supporting the officer's reasonable belief that an emergency existed. An empty holster, in the context of a suicide threat call, communicates that the person may have armed themselves, raising both the urgency of potential self-harm and the danger level of entry itself. What this means for gun owners. If you are a gun owner, the visibility of your firearms or accessories from outside your home through windows or open doors is now constitutionally significant in welfare check scenarios. An empty holster, a visible gun safe, firearms displayed on a wall, or ammunition on a table can become elements of the objectively reasonable basis analysis if police respond to a third-party call about your well-being. This is not an argument to hide your firearms. It is an argument to understand how their visible presence transforms a welfare check into a heightened emergency entry situation under case. The loop between firearms and police danger perception. When officers enter under emergency aid authority believing a firearm may be present, their tactical posture changes. Case himself was shot because he opened a closet door holding an object an officer perceived as a firearm. The sequence, ex-partner call, visible holster, warrantless entry, closet opening, shooting, has now been confirmed as constitutionally permissible at every step. For gun owners, this is not legal abstraction. It is a survival question. Number 3. Situations that create emergency aid entry authority. Suicide or self-harm calls, the paradigm case. A report from any third party, neighbor, ex-partner, anonymous caller, can trigger a welfare check. The report alone does not justify entry, but combined with responsive circumstances observed at the location, it does. Case establishes that report plus observable indicators plus occupant non-response collectively reach the constitutional threshold. Domestic calls with weapon elements. A call reporting a domestic disturbance referencing weapons. My partner has a gun and is acting erratically, triggers emergency aid analysis, even without specific self-harm language. If officers arrive and observe circumstances consistent with the reported emergency, case applies. Mental health crisis calls, calls that reference both mental distress and weapon access. My friend is having a breakdown and I know they own guns. Create the exact fact pattern case involved. The presence of any observable indicator supporting the report at the location contributes to the constitutional analysis. Number 4. What case did not eliminate. Objective standard is still real. Emergency aid entry requires an objectively reasonable basis, not a subjectively felt concern. An anonymous call with no details, a neighbor's general unease, or a hunch is insufficient. The observable circumstances must be specific enough that a neutral judge reviewing them after the fact would find them objectively consistent with the emergency claimed. Pure evidence collection remains prohibited. If the purpose of an entry is to collect evidence rather than render emergency aid, the exception does not apply. Officers cannot manufacture emergency justifications as pretext for searches they could not otherwise conduct. If evidence suggests the justification was pretextual, the entry and any evidence obtained may be suppressed. Post-entry conduct still governed by Fourth Amendment. Once inside under emergency aid authority, officers can address the emergency and observe what is in plain view. But they cannot conduct a general search, open closed containers, or pursue investigative activities beyond the emergency scope. Emergency entry authority does not transform into a general search warrant once inside. Number 5. What you must know to protect yourself under Case versus Montana. Manage what is visible from outside your home. The Case ruling was partially enabled by what officers saw through an open window. The visibility of objects in your home from the exterior, particularly firearms, holsters, ammunition, and any writing, has constitutional significance in welfare check scenarios. If you have visible gun storage or displayed firearms near street-facing windows, understand that visibility can contribute to emergency aid entry justification. Understand what a welfare check can become. A welfare check is not a routine administrative call. Under Case, a welfare check combined with observable circumstances at your home can become a warrantless entry. If you know someone might call a welfare check during a difficult period, being accessible to officers, answering the door, responding through a window, signaling that you are present and not in distress, is now constitutionally significant. Your non-response contributes to the justification for entry. If you are experiencing a mental health crisis, if you are in distress and own firearms, The combination of those facts plus a third-party report creates the exact profile case authorizes police to enter and address. Store firearms securely in ways not visible from outside. If you need support, reaching out through 988 or directly to a mental health professional is preferable to a situation where someone makes a welfare call on your behalf. Challenge pretextual entries. If police entered claiming emergency aid authority and the circumstances do not support objectively reasonable emergency belief, that entry remains challengeable. Consult a civil rights attorney. Document everything. Time and circumstances of entry. What officers said, whether investigation activities occurred beyond emergency scope, whether the justification appeared genuine. No suppression rights. If you face criminal charges based on evidence found during an emergency-framed warrantless entry, your attorney should examine whether the objective standard was actually met. Evidence from an entry that did not legitimately qualify under case may be subject to suppression under the exclusionary rule. Bottom line, Case v. Montana, number 2, 4-624, January 14, 2026. Warrantless home entry is constitutional when officers have an objectively reasonable basis to believe an occupant needs emergency aid. A third-party self-harm report, combined with visible indicators of means and mental state consistent with self-harm, combined with occupant non-response, collectively creates the constitutional threshold. William Case's case, empty holster, apparent note, non-response, met that threshold. What changed? Emergency aid exception now applies to combinations of factors rather than requiring independently sufficient visible emergency. Observable evidence plus third-party report plus non-response creates constitutional entry authority inferentially. What did not change? Objective standard requires specific articulable circumstances. Evidence collection remains prohibited. Warrant requirement remains the default. Post-entry conduct still governed by Fourth Amendment. For gun owners, visible firearms contribute to the observable circumstances analysis. The self-harm report, plus visible weapon indicators, is the precise fact pattern case affirmed. Manage exterior visibility of firearms, be accessible during welfare checks, understand mental health crisis protocol, and challenge pretextual entries through Civil Rights Council. Subscribe because Case v. Montana is already being cited in welfare check situations across the country, and how broadly courts apply this January 2026 ruling is being litigated right now.